go ahead and you can go to my Facebook page at Kim Hanson's Facebook page, and we'll be live there as well. And okay, let me just get this. Okay, great. Everyone can hear me loud and clear, except for maybe a few people. So welcome everyone. I want to welcome you to our live webinar, broadcasted both via webinar for the 200 and some people who signed up. And also on my Facebook page, I have Jonathan Judge here from, let's see, it's a long one, Jonathan. What is your law firm's name?
Yeah, we're Atkinson, Andelson, Loya, Rude, and Romo.
All right, that's a long one, and soon to be Judge on the end of that, right?
We'll see. It could be some years for that, but.
All right, Jonathan is an attorney, and he's joining us today regarding the Dynamex ruling. Jonathan, can you tell us a little bit about yourself?
Sure. So I've been practicing employment law here in California for 15 years now. I'm a partner with a law firm. We're based out of Cerritos, California, and we have 9 offices in California throughout the state, from all the way from Marin County down to San Diego County, and from the Bay Area to the Sacramento area. So we got the whole state covered with that. What I primarily specialize in is working with employers on their policies and their agreements and employee issues, day-to-day issues that they deal with. And our firm will also get involved in litigating cases, defending employers when they get either brought into court by one of their employees or brought before one of the agencies in California, such as the Labor Commissioner or the Employment Development Department.
Great. So you're an advocate of the employer.
That's, yeah, strictly we defend employers and represent employers. We do not represent employees.
Great. I think you're my friend. All right. And I'm Kim Hanson. I am a leadership development coach and executive coach with the nakedleader.org. I specifically work in the salon industry with salon owners, coaching and consulting. The reason why this topic is very important to me, Jonathan, and everyone, is because my salon was reclassified in 2006. And in that reclassification, it was long before, obviously, this Dynamex thing came up. But in that reclassification, I operated like everyone else did in the industry. I was what people would call a hybrid salon. I had booth runners and employees that were working for me. I was, at the time, I had originally opened my salon in 1993. And in 1993, I was all booth rental, and then I expanded and I had all these booth renters and I didn't really know what to do with them. I couldn't kick them out. And I wanted to start adding employees. So I started adding employees alongside the booth renters. And I had a few spa rooms. And in my the spa rooms were specifically rented out to booth renters or independent contractors per se. And one of my estheticians, or one of the estheticians who rented out a room, she was a very sweet, and I say this, and it's important that I say this, she was a very sweet 19-year-old girl who I'm sure didn't mean any harm, didn't show up for work for 3 days. And so I ended her contract, and she went down to EDD and she filed an unemployment claim, which kicked off an audit. So during that audit, it started out very ugly. Within 6 months, they reclassified me based on 3 things. There was a few of my booth renters that had my logo on their business cards. Because the estheticians and the people who were my employees had shared clients, they the independent contractors' clients were in my database. And the other reason was because I did not allow them to retail their own product line. So they reclassified everyone. And what ended up happening was I got hit with $120,000 in their back taxes and penalties on top of that. There was an audit there was 3 appeals that lasted 3 years. And on the final audit, the states did not invite us, actually, the attorney or the CPA, to the audit. And so consequently, nobody showed up and they ruled against us. And needless to say, it was a done deal. I owed the back taxes plus now even more penalties, and I lost my home. I did not lose my business. I want everyone to know, and that is why this particular issue is so important to me, and I've been preaching this since 2006, for all salon owners to know their risk that they take. And that's why I'm having this webinar, and the reason why I've invited Jonathan on today, because I want all salon owners, as well as independent contractors or booth renters, to know and to work together to what our industry is facing. So, Jonathan, what do you think about that story?
Well, yeah, I mean, it sounds pretty typical of the situation. You've got employees that you like and you get along with, and it just takes one thing that goes bad with them, and they go to either the EDD or the labor commissioner and claim that they weren't paid properly or something like that. And they start asking more and more questions about the business and the underlying practices, and then it can snowball into what you describe as the $125,000 audit, basically. So, we see that all the time. We're defending employers in different industries in that all the time. And, we've seen it in the salon industry as well.
Yes, it $125,000 audit that actually cost way more than $125,000 because attorneys and CPAs are expensive over 3 years.
That is true as well.
So, so we're here to talk about the Dynamex ruling. And Jonathan, can you explain briefly what the Dynamex ruling is? I think a lot of people already know what the ruling is. But for those people who don't understand, can you briefly explain what the Dynamex ruling is?
Yeah, certainly. So, in a nutshell, what the Dynamex ruling did was the California Supreme Court issued this ruling back in April, and they rewrote the book essentially on what it means to be an independent contractor in California under the California wage orders. So, and I'll get into more details on that, in a little bit. But the major part of it is that you used to have the Borrello test under California law for determining whether a worker was an independent contractor or an employee, and there was multiple factors, about 12 different factors that would play into that determination. And the major test was what kind of control the hiring entity exerted over the worker, but then there were other factors that they looked at. What this case did was go from that, flexible standard with, 11 different areas that you're arguing over, plus the control of the work. And you could say, look, these 6 factors weigh in favor of employee, but these other factors weigh in favor of independent contractor. And you would be able to argue about those different factors and make a case for, whatever classification you were advocating for. Under the ABC test, they've gone from, the 12 factors basically down to 3 factors, ABC. So simplifying the test, but also making it a lot more stringent. And that is, the business has to satisfy A, B, and C to have someone classified as an independent contractor. And if you fail any one of those, then the individual is going to be considered an employee. And so it's not a matter of, hey, we're good on A and C, but we fail B, so, the 2 overcomes 1. It doesn't work that way. Because you failed B, the individual would be considered an employee and not an independent contractor. So that's the basic mechanics of it. And anything you want to add before I go into a little bit more detail on it?
No, so basically it's just the law didn't actually change. It's just the way the law of what determines an independent contractor or a booth renter didn't change. It's just the determining factors, correct?
Correct. I mean, they've really narrowed down the test to 3 factors. We'll discuss those in a little bit more detail. But one thing to keep in mind, and that hasn't changed, is that the presumption has always been that a worker is an employee rather than an independent contractor. So you're always facing that uphill battle of establishing otherwise. And that was the case before this Dynamex decision came out, and that's the case now, is that presumption was against the business and for the employee. So that dynamic hasn't changed, but what has changed is the 3 factors that they focus on, that you can't, wiggle around some bad facts, basically. If you have bad facts, then, you're going to have to change those facts.
Okay, so can you define exactly what the ABC test is,
Sure.
Jonathan?
Yeah, so real quick here, the A part of the test is that the worker is free from the control and direction of the hiring entity in the performance of the work, both under the contract for performance and in fact. So this factor is really similar to the old control factor under the Borrello test that we're all used to, and that was in place for 30 years. The control over the work and what is being required of the worker is what's going to be determinative here. And an important fact here that's in their test is that it's both under the contract for performance and in fact. So not only will they look at the written agreement that you have in place with the individuals, but they'll also take a look at what the actual facts of the relationship are. So it's not enough to have one or the other. You need to have both to satisfy that.
Okay, so before, are you finished with A?
Yeah.
Okay, before we go on to B, can you give me a specific example that pertained to the beauty industry in regards to what would be what would either fail or pass the A part of the ABC test?
Right. So, I mean, there, from your example, you were requiring the individuals not to sell their own products, but to sell your products. And there, you're exerting control over the individual. And one of the straw that broke the camel's back in your case was that when that one worker didn't show up for 3 days, you terminated her. And that is another area where they would say you're exerting control over that individual, such that they're an employee rather than an independent contractor.
Right, which is, it's difficult, and I want everyone to know who's listening. It's difficult. Your name is on the sign. It's difficult to deal with not having a person show up for 3 days and dealing with, people who are pissed off at you. So having booth renters, which is actually when I flipped into all employees and everybody was reclassified, it was actually a lot nicer work environment, to be honest with you. So, okay, so that is part A of the ABC test. Now go on to part B.
Right. So part B is that the worker performs work that is outside the usual course of the hiring entity's business. And this is the real one that is throwing all employers for a loop. The issue in Dynamex involved delivery drivers who were, Dynamex was the big company hiring individual businesses to deliver packages for them. And so the court in that case looked at, the big company Dynamex. What do they do? They're in the delivery industry. And what are they hiring their workers to do? They're hiring them to make package deliveries. And there they said that was in the same line of the business as the main entity, and that failed prong B of the ABC test. And therefore the drivers were employees rather than independent contractors.
Okay, so can you give, I want to interrupt here too, because I didn't let I didn't let everyone know. We are going to get to your questions specifically after we finish a few of this business. So I want everyone to hold on. I'm not ignoring your questions. We are going to get to all of the questions, both on the webinar and on Facebook, or at least as many as we can before 5:30. So so back to part B, Jonathan. So part B, can you give me a specific example that would pertain to the salon industry that somebody would fail part B?
Well, yeah, so where you would fail part B is where you try to classify someone as an independent contractor, and your business, I mean, they're going to look at all the factors, but you're in business salon A, you're advertising it, and people walk in and they don't have anybody particular in mind ahead of time, and you just assign them to go work for one of the stylists there at the company, and you tell the employees what time to arrive at work, and they're cutting hair, they're, that's what you're advertising your business out to be. They're going to be, under prong B, failing that because they're stylists. You're a hairstyle salon. They're going to, say that you're in the same business as the individual.
Okay, so this is something that I think this is actually, this part B is the critical piece to a lot of salons.
Uh-huh.
And one of the things is, if a lot of questions, and I will ask a specific question that came in via email on this part B, but a lot of people feel that because they are a hairdresser themselves and also own the hair salon, that then they could fail part B. Is that true?
Well, I mean, it depends on, yeah, I mean, if you're trying to say that your business is a rental business, and that's all you do is collect rents, but then you've got your own booth in the corner, and you're also conducting, salon services as the owner, that can place you in jeopardy of violating or failing the test, because then you're no longer solely in the business as a rental business, but you're also conducting the services that you say you're not doing.
Okay. And then there's also some information floating out there that if you're not diversified and you're just, let's say, a hair salon or just a barber salon, and you're not diversifying your booths or your renters, or your business is not diversified into different areas or different businesses, that you could then potentially fail part B.
If your business is not
diversified. So say if it's all just, there is information that's out there that I think people have read, that if you're solely a hair salon and you rent booths in your hair salon, that if you don't rent to other people besides hairdressers, then you could be reclassified. Is that true?
I mean, that may be something that they look at. I don't think that would be a deal breaker. You could probably have, different, I mean, you could have a bunch of people doing the same thing. And if the business were structured correctly, or the arrangements were structured correctly, that would be something that could pass the test. But yeah, I don't see that you have to have, one person doing one thing and another person doing a different thing, and different techniques and different practices. Yeah,
I was once I had gone to a seminar with the IRS a few years back, and the IRS agent told me that if you rent a space as a hair salon to somebody and they want to repair lawnmowers at their station, that there's nothing you can do about it.
That's an extreme example, but yeah, the one you would use in your favor if you were ever audited and say, hey, we don't exert any control over what these folks do. They're free to do whatever they want.
Okay.
So, I mean, a less extreme example of that would be, that the person in the booth gets to dictate their own price, and they're not following a pricing list that you dictate on them.
Okay. So, and then part C of the ABC test, Jonathan.
Right. So this one is that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. And, this can be easily confused with prong B. They sound similar, but they're different, and they're phrased differently. for that reason. What this means in abstract terms is that the worker is engaged in a business that's separate from the established or the hiring business, and that they're doing the work that is appropriate for that separate business. So, for example, you have an employee or a worker who's licensed as a notary, and they've got a notary business, but they're performing stylist work for you, then they fail prong C. So really, you want to have someone there that is establishing their own business, separate entity, and this is where factors come in like the business card. They have their own business card. They do their own advertising. They, make arrangements for their own customers to, contact them and book appointments. And they're not relying on the hiring entity to do that type of stuff for them.
Okay. So I think that is fairly clear, and different from other industries, our industry has really another business model besides independent contractors, which is booth rental or chair rental. And then a fourth called suite rental, because we really distinguish them as separate things. People refer to them as suite rental, booth rental, 1099 employees, or 1099 independent contractors, or employees. So there's technically 4 different business models for an establishment to work under.
Uh-huh.
And I believe many people classify independent contractors as booth renters. And our booth renters, somebody who would pay you a monthly or a weekly rent, versus a independent contractor, would that be classified as the same thing? Somebody who's a 1099 person or a booth renter or a suite renter?
Yeah, I'll tell you, I've looked into this over the last few weeks to in anticipation of this webinar and other questions that are coming up. And in the eyes of the law and the entities that are making these determinations, they are equating the booth renter with the independent contractor. And specifically, there is a publication that the IRS puts out that they talk about booth renters, and this is the sentence that they open their section about. It's a booth renter is someone who leaves or leases space from an existing business and operates their own business as an independent contractor. So they just kind of throw in the terms there together such that they're basically considered the same thing. Same thing at the state level. Let's see here, a publication that is put out by the California Board of Barbering and Cosmetology talks about the independent contractor definition, and then right next to it, in parentheses, they put booth renter, and they open their section with this: independent contractors, parentheses, booth renters, are licensees who rent or lease a workstation in someone else's establishment. So it's all going to come down to the Dynamex test and the ABC, employee versus independent contractor. And really, from what I've been looking at, is that the booth rental is just one aspect that these agencies take a look at, but it's just one factor amongst the many.
So just because you rent a chair, or because you own a salon that has chair rental, just just because, you're not 1099ing people, but they rent a station or a booth or a suite from you does not, and that person 1099s you. So meaning that the stylist or the renter would 1099 the salon owner because technically anything over, I think it's $600, is that correct? Has to be,
Correct. Yeah.
Yeah, you have to give a 1099. So all booth renters or suite renters should be sending a 1099 to the owner of the establishment at the beginning of each year for the previous year, correct?
Yeah, whenever that threshold of $600 is met, then you're going to want to have the paperwork in place that that transaction is taking place from the booth renter to the landlord, so to speak.
But just because that 1099 is given to the owner of the establishment does not protect them from reclassification, correct?
Not necessarily. Yeah, I mean it's just one factor that they look at, and it's not a silver bullet that would save a business from being reclassified, and it's not fatal if you don't have that type of relationship in place.
Okay. So go ahead.
Yeah. One other point on this is the wage order, which is the whole basis for the Dynamex decision was the California wage orders, which dictate the minimum wage, overtime, meal and rest periods, etc. The wage order that's specific to the personal services industry, wage order 2, has a specific definition of employee in it, and it makes specific mention of rental. And here's what it says. Employee means any person employed by an employer and includes any lessee who is charged rent or who pays rent for a chair, booth, or space. And then it goes into 3 factors. 1, who does not use his or own funds to purchase requisite supplies. Number 2, who does not maintain an appointment book separate and distinct from that of the establishment in which the space is rented. And 3, who does not have a business license where applicable. So it goes to show you that even if you're renting under the definitions in the wage order, you could still be considered an employee. So they were aware of this situation when they wrote this document up.
And when was that document written up?
These have been in place for decades, since the 1970s, basically, and even before that in other formats.
Yeah, I think when I was researching back in 2006, it was 1947.
Yeah.
that I read something. Okay, so there is a lot of fear, obviously, happening in the industry, and which is why we had, so many people signed up for the webinar, and so many people are interested in this because of the fear factor, and because people want to protect themselves. And I think that there's been rumors spread around, by advocates of employee-based salons that booth rental is illegal in California. Is that true?
No, I don't think that's true either. There would still be situations, I think, where you can have a booth rental business, and this has been recognized in the past in the EDD, Employment Development Department documents. There is a publication that they put together in 2016 that is specifically geared towards the barbering and cosmetology industry.
Mhm.
And what it does is goes through in this case, it was 16 different factors, and they've got 3 different columns in there. They've got employee, independent contractor, and then the weight that they give each of these factors. And then they go through all of these. And they do talk about the rental, model in there, and what kind of situations would pass muster under the old, Borello test that they were using. So, underlying the whole ABC test is that, the factors are just kind of disguised in there in different ways, that you kind of do some reverse engineering of, prior decisions from the courts and the, different agencies, and they, the factors are still the same that they're looking at, just they look at it in a different manner.
Okay. So go ahead.
Yeah. So one other thing that lawyers always deal with is what has happened in cases before, and what can we learn from those cases. So unfortunately, the salon industry only has one case to rely on, and you may have heard about this, or you may have read about it a number of years ago. The Happy Nails Spa of Fashion Valley versus Julie Sue, who's the labor commissioner here in California. And so this case came out in 2013 and involved a salon that had many facilities throughout the California. And they were brought before both the Employment Development Department and the Labor Commissioner. And what happened was that in the first case before the EDD held their trial, so to speak, and evidence was presented about the workers at the salon, and the EDD determined that the employees, or that the workers, were independent contractors. And this was a case where they were renting booths, but they looked at other factors as well, what kind of advertising they were doing, what kind of business cards did they have, how are they charging clients, how is the money exchanging hands. So the Happy Nails won before the EDD. Then that was the good thing for them, but then they got dragged before the labor commissioner on the same issue. And the labor commissioner came to the opposite conclusion and found that the workers at the salon were employees. And so they had these 2 different decisions coming from basically 2 sister agencies of the California government. And what they did in this case was that they convinced the court that the first ruling should have basically ruled out any further rulings from the state on this issue. It's a legal concept called a res judicata, or collateral estoppel, which basically it's similar to double jeopardy in a criminal circumstance, that you can't be tried for the same thing twice. So here their argument was, we already litigated this before the EDD. It would be unfair for us to have to litigate it again before the labor commissioner. And fortunately for them, the court ruled in their favor in that case. But you could see how it could just as easily go the other way, and had the labor commissioner come to an adverse ruling against them in the first case, then under the rule in this case, the EDD would be able to rubber stamp that and also find against them.
Okay. So there's only one, attorneys only have one real case that they can really draw back on.
Yeah, so we can, get a realistic view of how a court would look at it, how the EDD would look at it, how the labor commissioner would look at it. I mean, we do have the publication by the EDD. I believe it's very helpful. I can give you the document number, DE, as in Doug, Edward, 231C as in cat. You should be able to find that at the EDD if you Google it, and it gives a lot of detail as to what they're looking for.
Okay. So we talk about licensing, and we have 3 different licenses in the industry. So we have a professional license that allows us to do what we do. We have, for those people who are booth renters or independent contractors or suite renters, we have a business license within the city. And then there's a 3rd license that we have, which is an establishment license. Now, there is some speculation that in order to be considered or not to be reclassified, that all of your people would have to have all licensing, meaning an establishment license as well. I don't know how, this is just speculation, and I actually have heard this from at least one other attorney. And so in the industry, we're not, unless you have a sole and separate address, the physical address, you can't get an establishment license. So I think this is what leads people to believe that booth rental is dead in California, is because that 3rd license, which meaning the establishment license, isn't able to be gotten because the State Board of California will only issue 1 establishment license per address. What are your thoughts on that, Jonathan?
Yeah, that's a good and interesting area to dig deeper into. As far as the first level of license, the professional license, the EDD's position on that was that in the salon industry, both employees and independent contractors are required to have a license from the Department of Consumer Affairs to perform cosmetology services. And then they gave that weight neutral. So they really didn't, give that much weight. What's going to be given weight under the ABC test is, what is the business license and then the establishment license. I think the more licenses you have, the better argument you have that you have an independent business. But beyond the business license, I don't know if the courts would insist that you have to have the establishment license to be able to establish the, so to speak, separate businesses. So I think it would be kind of icing on the cake to have it, but I don't think it would be, again, something that would, torpedo your business model if you didn't have it. And, that's because this falls under prong C of the ABC test. And, when you look at the examples that the Supreme Court issued in its decision, they looked at, other stuff beyond just the license of the business. That was one thing that they looked at, but they also looked at, what kind of business cards that they had, what kind of advertising did they do, were they free to go to work for other companies, where they, in the salon industry would be, you got one booth in Irvine and you got another booth in Cerritos for 2 different, companies. And, you're free to go to either one, and they're not going to say you can't do that. And that would be another factor that would be in your favor to pass C and convince a court that you're an independent contractor.
Okay. Okay. I have another question here. Will salons who have, do you think that the Dynamex ruling really poses a threat to the salon industry? This is very new. It just started, you know, the ruling was in April of this year, 2018. But do you think that it actually poses a threat? And if you do think that it does pose a threat, why do you think that?
Yeah, I mean, I think it does pose a threat. It's not a Chicken Little type of the sky is falling type of threat, but what it does, and you know, this has been pointed out by other folks before, is that, and I opened my remarks today with that the presumption has always been that a worker is an employee and not an independent contractor. And that is the same under the ABC test. We've just got a lot less room to argue against that presumption. But, you know, the independent contractor model is not dead. And, you know, other business models are not dead either. They're just, you know, they'll be harder to attain, and you got to be more careful about going about it. You know, and there are a number of you know, legal arguments that can be made about the Dynamex decision. That you know, number one, it is just related to the wage orders at this time, and it doesn't even extend to labor code violations. So like expense reimbursement, those types of things. So it was a very narrow ruling from that perspective. The other thing was that the distinction that they made in Dynamex, and it's probably not, it's probably more applicable in other industries rather than the salon industry. But you know, what they were really targeting in Dynamex was this big company that was hiring individuals that had their own business, and the business in that case, the smaller businesses, they did not have their own employees. They were owner operators of the trucks. And what happened in Dynamex is they excluded any employees or any of those businesses that had their own employees or that had their own clients that they did business with, you know, not just for Dynamex, but they were making deliveries for other companies. So those were excluded. So there is where, you know, if you had a lawyer arguing your case, that you would say, well, Dynamex does not apply in this situation because this business has its own employees, or, you know, it is doing business with, you know, 3 other, you know, rental facilities in the area, and just operates here, you know, a couple days a week and goes elsewhere on the other days of the week.
Okay. So, all right, now I'm going to get into some questions that were sent in via email. But prior to doing that, and I want everyone to know that if they have a question on the webinar, please type it into the chat box and not in the Q&A. And if you have a question on Facebook Live, please type it into the comments section on the Facebook Live. And we're going to get to the those questions in a second. Prior to me getting to those questions, and while we're still sitting here chatting, I'm going to launch a poll to the to the people in the webinar, and the people on Facebook Live can definitely answer as well. So the first question is, what is the biggest drawback for you with a W-2 business model? A is I can't afford it. B, I don't want the responsibility of employees. C, it's hard to find service providers that want to be an employee. Or let's see, A, B, C, D, E, none of the above. So the people that are on the webinar are polling. I'm going to leave that poll open. And the people that are on the Facebook Live can go ahead and answer that as well. And I have another question as well too, but here I'm going to have, before I ask another question, Jonathan, here's some questions that are sent out via email. Is it legal to place the salon and spa as a leasing space to stylists into my LLC?
I mean, first off, I'm going to have to be frank about, or candid about, the legal advice I can give out, in a webinar to anonymous folks out there, and, answer in hypotheticals only to the, the best of my ability. And, we can always consult on more specific factual situations, on a one-on-one basis. So, Rip, tell me again the question there.
I think people are trying to find a way to protect themselves. So this person wants to know if she wants to know if it's illegal to place the salon and spa as a leasing space to her stylist into her LLC.
Yeah, I mean, it's difficult to answer that, but there would be, you'd have one business that is renting out spaces to other individual businesses, and that's not necessarily going to be a silver bullet to fighting or a defense against liability. They're going to look to those other factors. One of the things that I was looking at was, this ABC test was basically adopted from Massachusetts and, other states that have had the ABC test in place for years. So, not only have I looked at, past decisions in California, but also looked at, other decisions in the salon industry in other states. And there was one in Maryland that, believe it or not, from 1963, that involved a rental business and a barber shop where the owner, he did his own, barbering services, but also rented out 4 booths during the busy summer months. And the Department of Employment in Maryland found against Charlie's barbershop in that case and said that the 4 folks that were renting the chairs from Charlie were his employees, despite the fact that he charged them rent. They also looked at the other factors in that case, but the interesting thing that the court said in this case was that when they created the ABC test in Maryland, at least, they said at the inception of the unemployment insurance program, it must have been apparent to the drafters of the statute that employers would attempt to avoid coverage under the act by creating lease arrangements. And for that reason, a special definition of employer-employee relationship was included in this statute, which was the strict ABC test. So, that just goes to show you that, we've been playing this cat and mouse game for decades, not just in California, but outside of California, with regard to rentals. One thing that got him into trouble in this case was that his rental fluctuated. So he was, charging them rent based on a percentage of the revenue that they brought in. So, it was much easier for the court to say in that case, well, that was just really, a disguised form of, paying them, but, taking out, some of the profit that he would have expected had he just been paying them directly.
Well, I think my story is a perfect example. I was reclassified in 2006 under the Barillo, whatever, what's the word I'm looking for, Jonathan, under the Barillo test or whatever. So I think a lot of it is up to the auditor and the CPA or the attorney you have. Yeah. And I highly suggest that, people do get very good legal advice, because I think what the ABC test did is it defined it even more and didn't leave it so broad and so open to the auditor's opinion, possibly. Yeah. So in some ways, I hate to say this, but in some ways it's a good thing, because in my experience with the EDD is I had over a series of, a couple of years, a lot of training mistakes that happened in the EDD, which led to a lot more problems for me. So the fact that it's very clear and less broad and less open to opinion, I think is actually better for the business owner in the long run anyway. It just creates more clarity, and where there's more clarity, there's less mistakes, correct? And that's why I think that there's a lot of people that are concerned, because they just want to be clear on what they can do or what they can't do. Yeah. So here's the second question. The retail is this is a person that wrote in, the retail in this guy's salon is being reconstructed as the store. Would it be legal to have a reward program with accumulated points for stylists to use in exchange for products from the store?
The question on the retail and the sales and commissions, it's a tricky one. Under the old EDD publication here, before Dynamex came out, the way they looked at it was that as long as the hiring entity did not require the worker to sell a particular product, then, if they wanted to do it independently, they could pay the worker a commission if they sold some product. But they would also the worker would be free to sell their own product that's not the store's product in that case. Now that's under the EDD standard. I've looked at other industries where you have the ABC test and the involvement of sales, and it is problematic to try to pass B prong, where you're making part of your business the sale of products, and then you're employing individuals to sell those products and then paying them for selling those products. Well, that smells to me that it would fail prong B of the test. So
I have something to say. As a coach and as a salon owner and as somebody who has been reclassified, this is what I have to say about this. in regards to retail, your salon owners are giving stylists commissions or bonuses or whatever it kind of incentive it is as an incentive to sell their product. My question to that salon owner is simply this: is it worth it? Is it worth it to risk reclassification by giving some sort of incentive on retail products that's the reason you could be reclassified for? So that's, as a coach, that's what I would tell my client.
Yeah, basically trying to disguise the compensation as some type of incentive, you know, they're going to see through that.
I think so too. So this is the third question. If the independent contractor leasing space from the salon spa, is it legal to pay the landlord for booking services or laundry services?
Yeah, again, you know, the old EDD publication here talked about the laundry and said that, you know, it implied that that could be part of the, you know, facilities that the individual is renting, and that would not, you know, endanger the independent contractor type of situation. But again, we go back to the definition of employee under the wage order. And remember when I was talking about it includes people who rent, and then the three factors that were underneath that. And one of them was that they have to keep their own separate clientele. So, you know, where you're blurring the lines on that with regard to providing booking services for the individuals that are working at the salon, then I think you're getting into that gray area of danger.
And also, speaking as a coach and consultant, how I would answer that is I would, again, it's if risking reclassification and risking the money that you're going to spend on attorneys and or legal fees and accounting fees, and, you know, again, you guys, I lost my home. Is it worth providing services? I mean, the laundry is something that I believe Jonathan said that you can do. However, with booking services, currently we all have databases. Very few people have paper books anymore. It's all software, run through software with a person answering the phone, which could actually reclassify somebody, because that could be misconstrued as control. Correct, Jonathan? Would you say?
Yeah, I mean, that was one of the, you know, examples that is listed in this publication, is that, you know, walk-ins, you know, what happens with walk-ins? Are they, you know, referred to someone in particular, or does it not happen and they have to, you know, book a particular stylist ahead of time? You know, where, you know, you have two entities getting involved in booking, there is going to be that, you know, element of control, where one is having an ability to assign, you know, clients to particular people.
Yeah. Another question: are booth rental salon owners allowed to provide free weeks rent to booth renters?
You know, I think that would be an area where you would, again, get into trouble, because then, I mean, you're basically taking away any risk that the renter has with regard to their entrepreneurial, you know, abilities, and you're taking all the risk, and that is a classic employer-employee type of of relationship. They would, say then that, really for at least a few months, your rental agreement is nothing but a sham.
Mm-hmm. I agree. I think if you rent an apartment or you rent a house, you don't get free week's rent from your landlord. It can misconstrue like back to that incentivization to whatever. Another question: Are booth rental salon owners allowed to provide commission? Oh, we already answered that question. What if everyone in the salon, hair and nails, are on the building lease?
I guess that would be almost like a kind of a collective situation, which I haven't really looked into, but there they would be each paying a share of the rent, if I'm understanding the question correctly. So, that may establish that each of them are separate businesses. Mm-hmm. But again, they would look to, other factors that, you got the business that's renting out to the 8 different or 7 different people. And is there anything else going on beyond collecting the rent is what they would look at. That would start, eroding that, determination.
Okay. And then I've had a couple people send in an email. They want to switch because there's this concern that they're going to fail. I think it's prong B of the ABC test if they provide services in the business alongside their booth renters. And so there's people are wanting to change ownership into their domestic partner or a partner's name, and then they would then become a booth renter from that salon as well. But before you answer that, what I have to say as a coach is it doesn't really matter if your salon is operating as a legal booth rental salon. And remember, the law didn't change. It's just the determining factors changed. So the law remains the same. But if you're operating as a legal booth rental, where, like say for me, I work at 2 salons. I coach. I am clearly an independent contractor. Sometimes they never even see me for 2 or 3 weeks in that salon, and they never even text me like, "Where are you doing? What are you doing?" So I think if you're operating as a legal booth rental salon, you shouldn't really worry about reclassification. That's what I have to say about that. Legal, if you're operating legally, I want to stress that. But switching the name from, John to Betty, which is your domestic partner's name, and in order to pass prong B of the ABC test, would that be something that people would need to do, Jonathan, so that they become a booth renter in their own business?
A lot of times it may just be like moving the furniture around on the Titanic, because the labor commissioner and other agencies in California have become very savvy to this being done. We deal with employers in all kind of industries, and there'll be situations where a business, and there's a lot of court decisions about this, where a business shuts down and then restarts under a different name, but then, different ownership supposedly. But they'll look at the underlying, facts of the situation, and are the same workers there still? And if the answer is yes, that's a ding against that, separation. Are the customers the same? Is the location and the advertising the same? They're gonna look around at those types of things. And
Yes.
beyond that, the labor commissioner or the legislature in California, it passed a new law a couple of years ago that said, despite the ownership situation of the company or the legal, corporate entity status of a corporation, that, if it goes belly up, that the owners and managing agents can still be liable for wage and hour violations to the employees. So you're not going to be able to hide through a change of ownership or a change in corporate status as a means of escaping liability.
Okay. So now I'm going to go to the questions from our people in our webinar.
Uh-huh.
I'm reading through them. Here's another one. My boyfriend and I are business partners. He is a barber. I'm an accountant. How will this work under the law? I don't think that really makes any difference. We just kind of define that, didn't we, Jonathan?
Yeah, I mean, it's a good example. So you got a salon, you got an accountant. So, the accountant can do business for the salon as an accountant, as an independent contractor, because, there you're passing prong B, because you got separate types of businesses there. And, if you're properly licensed as an accountant, then you're passing prong C, and you're doing accounting work and not hairdressing, then you're passing prong C. And, prong A is going to be pretty easy. The boyfriend's not telling the girlfriend when to, do her accounting work. She's got control over that and can come and go as she pleases. Then you would pass A.
Okay. So another question. So we can't fire someone, but we can evict someone, question mark. So what if, going back to my reclassification where I let somebody go for not showing up for 3 days, and technically I did enter her contract. I didn't really fire her, but I had a clause in the contract that stated that I could evict them at will.
Uh-huh.
And it didn't matter that that was in the contract. I still was reclassified. So what do you have to say about that, Jonathan?
Yeah, so that was one of the things that they looked at, under Borrello, and the fact that you could terminate at will is indicative of an employee relationship. And, here we're just playing, word games with whether it's ending the lease or ending employment. With that regard, the independent contractor relationship is going to take something more, a breach of the agreement. Her failure to pay rent would have been, grounds to terminate the lease agreement, not just necessarily not showing up for 3 days. So there's more of a business type of relationship there, that you're ending the contract and living by the terms of the contract to be able to terminate it. So you got to be in what we would call breach of the contract before it can be terminated. You can't just at will decide to terminate it.
So I have another question. If you have a written agreement contract that a 30-day notice is given, would that be acceptable under that situation?
Again, that's another factor that would weigh towards independent contractor status. because usually we don't see that in the employment context. It's usually employment at will. So, 30-day notice would be more of something that would be negotiated by two different businesses. And, that could be either shortened or extended, depending on, what the parties want.
Okay. The independent contractor is not paid by anyone but the client they service. So how would they be an employee? Do they have DBA business licenses? They have DBA business. Oh, I think she's saying that they have DBA business licenses. So,
yeah,
okay.
I mean, one of the factors that they look at is the flow of the money, and where it is going directly from the client or the customer to the stylist. That's more of an independent contractor relationship, but where it's going from the customer to the third party, then to the stylist, then you got more of an employee relationship between the stylist and the entity that's collecting the money.
Right.
So that what they talk about in these in this publication is who's bearing the risk of someone bouncing a check in the old days, or not paying for the services because they're unhappy. If it's on the stylist, then then it's more of an independent contractor. If the risk is going to be on the business that's working with them, then there's going to be more of an employee type of relationship there.
And I think that's an important, you've mentioned that a couple times, risk, who takes the risk? The risk, if just like if you're going on vacation, you still have to pay your rent. That's a risk of a business owner, meaning if you have a booth rental salon, your booth renters, if you purchase inventory, who's going to risk that inventory not being sold? If you allow your booth renters to, which technically you should allow your booth renters to retail their own retail product, and if you don't allow it, then that is illegal, correct?
Yeah, that would be another indication of control, that you're basically telling them what to do, what not to do, and that's kind of what you would tell an employee, not an independent contractor. They would say, hey, I can do whatever I want. I can sell whatever I want. You can't dictate what I'm selling.
Another question, will having a rental company where the independent stylists pay rent to versus salon owners satisfy the B factor?
I think, if you're looking for a good example of in the salon industry, what would satisfy B would be where you have a company that is just collecting rent and doing nothing else. And so they would be able to say, we're in the space rental business, not the salon business, and not the cosmetology business. And the folks that we're contracting with are stylists, and they're dealing with their own clientele. We got nothing to do with their clientele.
Yeah, and I think that's where people are wanting to morph their business model into a rental company or an LLC owned by somebody else, so that they can pass that prong B. I don't think that. I think that a lot of people are worried that if they, as the salon owner, are working in the salon, that's a reason to be reclassified. So there again, it's, without giving out, specific legal advice, and knowing a specific situation, if somebody set up a business as, you know, a leasing company, or a like an apartment that doesn't have walls, so to speak. The apartment owner would he live and lease an apartment as well? You know, like.
Yeah, you start blurring the lines there and endangering your business model there if you start doing the same work side by side as the workers. That's one of the classic situations where, in your old business model that got you into trouble back in the day, you had people working side by side in two different classifications, and that is going to be another thing that they look down upon under Dynamex, where you have employees performing the same type of work as a supposed independent contractor. They're going to say, well, really, your independent contractor is not an independent contractor, it's an employee.
Right, and that brings us to the next question. How can we dual commission rental and salon? You can't. If you want to be, if you don't want to assure that you're not going to be reclassified, you can't be a hybrid. You have to be, you are at risk for a higher risk of reclassification if you have a hybrid salon where you dual employees or 1099 people or booth renters. You are at a greater risk if you have two or all three of those business models. And that's just a fact, right, Jonathan?
Yeah. I mean, that's pretty clear from these, the decisions in the past is where there's a mix of different, approaches that there's going to have to be a real reason for the mix. And if the folks are just, it's out of convenience, they're going to look through that and say that, people doing side by side or, trying to bring in different revenues of income to the business, it again, makes those lines less clear between the two separate businesses and makes it more of an employee type of relationship.
Okay, so another person, can he give an example of a salon that's okay and fits within these rules of independent contractors? Like if they have their own cards, books, guests, they choose their days they work, hours, services they offer. This lady says she owns the building, but she's not behind the chair. She has booth rental only, and they can refer retail to her if they want. I would say that would pass. If that is all true, that would pass all three parts, as long as you're just careful not to incentivize the retail.
Yeah, I mean, I would be a little bit more cautious, but that's my nature as an attorney. Where the retail starts crossing over, I know that the old EDD standard would say that, as long as that's not required by the building owner, that it would be, it wouldn't endanger the relationship there, that they're independent contractors. But under the ABC test, I'm just not so, certain on that one.
Okay. So always best to let them retail their own retail.
Yeah.
Okay. Does this mean salons cannot promote their independent contractors on their website?
Yeah, that would be a no-no.
Yeah, big no-no.
I mean, then yeah, the test even under the old factors would be that they're looking for the individual stylist to be promoting their own business and expending their own funds to do that,
Right.
and not relying on the company to do that for them.
Right. And then the salon, they can't use the salon's logo on their cards. No, because I'm going to just straight up say no, because that's one of the reasons they gave me that I was reclassified is their logo was on, my logo was on their business cards in a very small area, just to show that they were working in the business. It wasn't even like a big giant logo. It was just on part of the card alongside their logo, their own names, but nonetheless, it was my logo on their business card.
Yeah, yeah. If they see the individual's names next to the logo, they're going to make that association, that the two are associated.
And one of the things is too, if the salon is doing any marketing, even a website, it could potentially be risk reclassification.
Yeah, because that again, that is that whole prong B as to the argument against that they're separate lines of business. If the owner of the building is advertising that it's a salon and bringing in business that way to its independent contractor salons, that's getting into that dangerous area of prong B of both businesses being in the same line of business.
Yeah. So if you wanted to have a website up as a booth rental salon and gear it towards stylists, but not towards the public, each individual business owner has to have their own website, do their own marketing, and you cannot market for them at all. Where can we find, so if you want to, we're almost done, but for anybody who wants to know, the recording will be on Facebook Live. It will also be on my website, www.thenakedleader.org. That was a question. What kind of trouble could booth renters face if they should be, they were found or they were reclassified? Would they face the same problems as the salon owner, or would the salon owner get in trouble? I can answer that. The people that work for you, if you're reclassified, they go scot-free, and you're the only one in trouble, because it is your responsibility. The state, and go back to the beginning of the webinar talking about that the state assumes that you have employees, and it is the burden of proof is on you, the salon owner, to prove all three parts of prong B, or all three parts of the ABC test. So, so if you can't prove that, you are the business owner. Therefore, you are liable and responsible to collect and pay their taxes. And they don't get in any trouble for it. Only you. Correct, Jonathan?
Yeah, I believe the real risk here is on the business owner, and to be a little bit more specific about what the risks are. That there's the back taxes, then there's all the wage and hour type of penalties that come with mispaying employees and misclassifying them. There may be off the clock time that they would claim that they were not paid at the minimum wage, and then there's liquidated damages that come on top of that, and then meal and rest period penalties, etc.
Right.
So it really snowballs, unfortunately, with with the penalties for misclassification.
Yeah. Seems like the business owner, here's another comment. Seems like the business owner, as business owners, we have no control or say in their business. They just operate a shell for other people to work under. Is that correct? It's correct. Right?
I mean, that's kind of the essence of the concept here is that one thing that they look at is how much control is being exerted by one company over the other, and there should really be a hands-off approach if you want to keep that separate.
Another question, what about a hotel salon? Stylists rent a booth, but also get hotel clients on commission. Oh, goodness. On commission, the hotel rents space to the stylists from their own clients, reverse commission on the hotel guest. Does that work? I'm confused. Are you confused, Jonathan?
It kind of reminds me of some of the examples that they talked about in the Supreme Court decision, and the argument there would be that the spa services that the hotel is providing is part of their main function. It's not necessarily I can see people out there saying, hey, they're a hotel, not a spa. You're contradicting yourself. But they do look at, there was an example in the case where they were talking about a museum that was offering art classes, and they said that the art instructors were employees of the museum. Even though people go to a museum to look at art and not necessarily take art lessons, this was something that was integral to the museum making money and something that they sold to the public. And I think the same type of argument would be made here with the hotel, that even though it's not their main part of business, it is an integral service, and that they make a good chunk of money out of it. There is another case out there against Grubhub, the gig economy employer, and they tried to say, we're not in the delivery industry, we're in the food. We put customers in contact with restaurants, and that's our industry. And they said, no, a big amount of your revenue is the delivery of the food from the restaurant to the consumer, and you can't compartmentalize your business in that way to say that that part of your business is independent.
Okay, I hope that answered that question. Okay, I'm gonna just, I have like so many more questions here. We're not going to be able to get to all of them. Jonathan, it is 5:30. Actually a few minutes past 5:30. I'm gonna scroll through real quick. So a booth renter could come back and sue the salon owner for unpaid wages, OT, and other things, even if the booth renter took their own payments for services and booked their own appointments. What's the safest thing to do, booth renter or employees? So the answer to that is yes, they can. Correct, Jonathan? They can come back and sue you.
Correct. I mean, that's what's, we saw a lot of that in the trucking industry, where, for years, the worker was okay with being classified as an independent contractor. They made a lot of money, but then, they turn around and say, I should have been an employee, and they make a lot more money on top of that.
And so the safest thing to do is to just pay the taxes and for your staff and make them employees. It's what I did. It was the safest thing to do. So what is the time frame after a renter leaving? Are you clear from them filing a complaint?
Yeah, so that is unfortunately a 4-year statute of limitations on wage and hour claims in California. So they can go back as far as 4 years under what is called a Business and Professions Code 17200 case for unfair business practices.
I have another question here. No more hybrids question. I would advise against that as a coach. I would say if you are a hybrid salon, you are, again, more at risk. I know there's a lot of hybrids out there. I'm going to have to close it up because Jonathan's time is valuable, I'm sure. I hope this was helpful to everyone. Just to go through the poll, and again, I really, really apologize for not getting to everybody. I feel horrible because there's so many more questions, and there's all kinds of questions on Facebook that I can't get to. However, if you do have questions, you can email me at kim@kimhanson.net, and I can help you answer your questions, or you can, and I caution this, Jonathan, but Jonathan is also available. However, he is an attorney and he has given us 90 minutes of his time today. So if you do want legal advice, please respect his time at judge@aallrr.com. You can get a hold.
That's correct, yeah.
Jonathan there. So the answer to our polls are: what is the biggest drawback for you in a W-2 business model? 19% said I can't afford the payroll taxes. 24% said I don't want the responsibility of employees. 35% said it's hard to find service providers who want to be an employee. And 8% said changing business models scares the hell out of me. And 14% said none of the above. Our second question, what do you think you would do if you were reclassified? 35%, which I'm so happy to hear this. I'm a salon owner. I would learn, grow, and still be successful. Fantastic. 22%, sadly enough, said I'm a salon owner. I would be forced to close my business. 24% said I'm a salon owner. I have no idea what I would do. 8% said I'm a service provider. I would leave the salon and continue to be independent. Nobody said I'm a service provider. I would trust my boss to do what was best. That's none. 11% said I'm a service provider. I have no idea what I would do. And then there's the third question, and I would also ask the people on Facebook to let us know as well. I did this about halfway through our webinar, Jonathan.
Yeah.
So hopefully we were able to answer a few more questions. But was the webinar helpful, and did Jonathan and Kim answer your questions? So about halfway through, they said, yes, thank you, 43%. And 57% said somewhat, but I still have more questions. So I hope that the last 45 minutes or so of the webinar, we were able to answer some more of your questions. Again, I would like to thank Jonathan Judge for coming out, and he is with the law office of Atkinson, Andelson, Loya, Rude, and Romo, right?
Very good. Yes. Perfect.
So I want to thank Jonathan for joining me and helping us wade through all this. Again, if you need assistance, and please respect his time, that he is an attorney, and he does assist employers only in their legal matters. You can contact Jonathan at judge@aalrr.com. Jonathan is also a Naked Leader preferred salon partner. So his link is also located on my website at thenakedleader.org under the preferred salon partner page. And so you can just go to my website and click on his bio, and it'll send you directly to Jonathan. You can also, again, you can contact me at kim@kimhanson.net for any coaching or consulting purposes, for business model conversions, pay conversions, anything you need to just level up your business. If you have any more questions, again, apologize if we didn't get to them today, but you can email me any questions or go to the nakedleader.org website for more information about my personal services. And I will post the links to Jonathan's law firm and my website in the comment section of our Facebook group that we've got going live here. And so I think that is it. Okay, John?
Well, thank you. Yeah, thank you, Kim, for putting this together. And
all right.
yeah, my pleasure talking with everybody today. And yeah, I know it's a lot to take in and try to understand. And there's a lot of gray area in this. And, you know, that's the typical thing that we deal with whenever a new case comes out. That there's a long period of uncertainty until we do see finally some, you know, litigation and get some clarity on where things are going.
Yeah, it is a lot to wade through, but it's a good thing the government's not real quick, huh, Jonathan?
Yeah, they're very overwhelmed with what they currently have going on.
So it gives all of us plenty of time to get all of our ducks in a row and be legal. Don't panic, everyone. It's going to be okay. Just make sure you're legal. And again, if you have any questions, please feel free to reach out. Thanks again, Jonathan. And everybody, good night. And have a wonderful Tuesday evening and the rest of your week.
All right,
bye.
Thank you.
Thank
Bye-bye.
you. Bye.